Section 5.1.5 Problems with the Courts. I'm Dr. Adam McKee, author of Criminal Justice, an overview of the system. Today, we'll explore the significant challenges facing the courts in the United States, focusing on the high volume of cases and efforts to reduce caseloads and speed up court processing. High volume of cases. One of the most significant challenges facing the courts today is the high volume of cases they must process. In 2020, the combined filings for civil cases and criminal defendants in the U.S. District Courts totaled 324,910. According to the Court Statistics Project, over 8.3 million cases were processed in state trial courts in 2019. This high volume of cases is due to various factors, including stricter sentencing laws and increased enforcement efforts, which have led to an increase in criminal cases. As a result, most state courts are perpetually behind on hearing cases. This backlog can delay justice, leaving defendants, victims, and the public frustrated. Reducing caseloads. Courts have tried various approaches to address this problem. One effective strategy has been the implementation of alternative dispute resolution, ADR, programs such as mediation and arbitration. These programs aim to resolve cases without going to trial, saving time and resources for both the courts and the parties involved. Another approach involves technological solutions, such as electronic filing systems and video conferencing. These tools can streamline the legal process, reduce the need for in-person appearances, and speed up case resolution. Drug courts. One of the most popular efforts to reduce caseloads in the United States has been the implementation of drug courts. These courts differ significantly from regular courts in that they tend to sentence nonviolent, first-time drug offenders to drug treatment rather than probation or prison. The primary goals of drug courts are to reduce recidivism and alleviate the backlog in traditional courts. Empirical research suggests that drug courts are more effective at reducing recidivism than traditional probation or prison sentences. In a study conducted by the National Institute of Justice, researchers found that drug courts reduce recidivism rates by an average of 8 to 26%, depending on the offender type and the follow-up length. Drug courts employ a collaborative approach to addressing drug addiction and criminal behavior, bringing together judges, prosecutors, defense attorneys, treatment providers, and probation officers to address the underlying causes of drug addiction and reduce the risk of reoffending. By addressing the root causes of drug addiction, drug courts aim to reduce the burden on traditional courts and help offenders successfully reintegrate into their communities. While drug courts have shown promise in reducing recidivism rates and alleviating caseloads, they are not a panacea. Some critics have raised concerns about the potential for unequal treatment and coercive treatment, particularly in cases where offenders are mandated to participate in drug treatment programs as a condition of avoiding incarceration. However, drug courts remain a popular and promising approach to addressing the complex issues of drug addiction and crime in the United States. Speeding up court processing. When there are too many cases to process, the speed at which cases are resolved can slow down, sometimes significantly. This is particularly problematic in criminal courts, where defendants have a constitutional right to a speedy trial. When the legal process becomes long and drawn out, the public may become dissatisfied. To address this issue, there have been efforts at both the federal and state levels to ensure that cases are resolved more efficiently. At the federal level, the Speedy Trial Act of 1974 sets time standards for 2 stages of the legal process. The law requires that the prosecutor arraign a suspect within 30 days of their arrest and that the trial takes place within 70 days of the indictment. Every state has followed the federal government's example by enacting speedy trial laws. However, the specifics of these laws can vary by state, and the implementation and enforcement of these laws can be complex. In some cases, speedy trial laws may allow for certain delays or extensions, particularly in cases where the defendant requests more time to prepare their defense or when the court experiences a backlog of cases. In conclusion, the high volume of cases facing the courts today is a significant challenge that requires innovative solutions. Alternative dispute resolution programs, technological advancements, and specialized courts like drug courts are all efforts to reduce caseloads and speed up court processing. Despite these efforts, there is still much work to be done to ensure that justice is served promptly and efficiently. As we continue to explore the complexities of the criminal justice system, it is essential to recognize the importance of these efforts and to support ongoing reforms that aim to improve the efficiency and effectiveness of our courts. Thank you for joining me, Dr. Adam McKee. in exploring the challenges facing our court system and the efforts to reduce caseloads and speed up court processing. If you found this video informative, please like, share, and subscribe for more insights into the criminal justice system. Don't hesitate to leave your thoughts and questions in the comments below. Until next time, stay informed and stay engaged.